So with that, I'm going to have Mark just start a little bit about sort of the prepared remarks before we get into the panel discussion. And all of our mics are on, so we don't need to transfer.
So, hello, everybody. Nice to see you. I forgot my readers in the other room, so I ran to my buddy Sean Kelsey to get his readers. I'm in good shape now. It's tough getting old. So one thing, Alan and I have worked together for 20 plus years. I helped triage Colpick's legal risk management stuff when I was in private practice before I came over. And one thing, Alan was very much involved and is very much involved in these Candor programs. So one thing that we don't want to have get lost is this panel is going to talk a lot about the law and that piece of the pillar, the 7-pillar process. But what's really important to remember, this is like the 7th pillar of the pillar process, because you've heard all about empathy, communication, apology. So this is more of a very unique process that Iowa has passed as legislation that really weaves in and out of all of those very important pillars. And so this should not be looked at in isolation from all of those other things. Having represented maybe 700 or 800 docs in my career, kind of knowing what motivates them, what fears they have, what concerns they have, this Candor law addresses a lot of significant issues. And why is that? Well, we've got the tort system. So some of you, if you don't recognize the term tort, that simply means somebody bringing a personal injury suit against somebody else in the litigation system, and we call it a tort system. So what are the bad things we've learned about the tort system over the last 50 years since medical malpractice has become, a very usually used claim? One is destroys the healthcare provider-patient relationship. I don't think out of my 700 or 800 cases, maybe some medical board cases that were overbilling, I don't recall the relationship ever surviving a lawsuit being brought. But there's no magic that says you have to terminate a physician-patient relationship because of a lawsuit. You shouldn't talk about case, of course, with a patient, but there's nothing that says you can't continue. But they don't. And it's because of the fear, the hard feelings, the sense of isolation, and the lack of trust that they don't continue. So what are some of the other things that the tort system fails at? Clearly, it's a blunt instrument. Lawyers will tell you, and I've done, I've never sued a doc because I don't quite understand that when you do both, but I've done plaintiff's work in other areas. And so, there certainly is an argument that cases help, kind of monitor the healthcare system to make sure bad things doesn't happen. But really, it's a very, very crude and blunt instrument from that standpoint, because what tort is about is reimbursement for injury, whereas it doesn't really focus on remediation or teaching the healthcare provider what went awry that perhaps could be changed. Because we actually have this fear of, if we do, quote, subsequent remedial measures, and that's a term of art in the law, we're worried that's going to come into evidence. That it's going to show that, okay, there was a screw up because we fixed it, and here's how it was fixed. And the law says that can't come in under certain circumstances, but frankly, there's so many exceptions to that, it almost always comes in. So look at what happens. So you've got destroyed relationship, lack of trust, you can't fix anything because you're worried about it. And I, growing up as a pup, I started doing Colpick's work in '85 along with every other carrier that ever wrote in the Rocky Mountains. The admonition is keep your head down and keep your mouth shut. I mean, that's the admonition that healthcare providers got and what we told to our clients. The lack of transparency to the patient, I would anecdotally say that probably 1/3 of my malpractice cases I was defending, 1/3 were caused because the patient couldn't get answers. Nobody would tell them what happened. So they said, fine, I'll go get a lawyer, I'll go to formal discovery, I'll get written questions, and I'll depose these guys, and I'll find out what the heck happened. And that motivated at least a third of these cases. And then finally, right or wrong, certainly there are care providers that the medical board, the nursing board, need to know about because, again, they focus on patient safety and it's important that they be able to do their job. However, I have seen a number of cases where a physician makes the mistake of their life. They are a fine physician, a mistake is made, somebody has suffered by it, and one of the clear barriers to getting cases resolved is the fact that all of this has to be, any claim that's settled has to be reported to the National Data Bank and to the medical board. The younger docs especially, the spectrum I always talk about is the doc that can't see straight because he's so mad that he's sued. The one on the other end is the mea culpa, mea maxima culpa, even though their care was great. They feel that since a patient was injured, they have to compensate in some way. So, this law kind of helps bring the healthcare provider to the middle of that spectrum. So it really is meant to address a lot of those failures of the tort system that we've experienced. So what are the important things? Well, anytime there's any adverse healthcare incident, so it doesn't have to be somebody did something wrong, it just is there's been a recognized complication or an unrecognized complication that's happened. And this year, the Iowa legislature expanded it dramatically. It was only applying to serious bodily injury. Now it applies to any physical injury that occurs. So candor can now be used across the board. They also expanded it beyond allopathic and osteopath docs to include any healthcare provider in any hospital facility. So it's usually very expanded. So there's some legal stuff that has to be done in writing in order for there to be the protections of candor. And so in writing, within 180 days, and you can kind of see, well, how does 6 months square with what we just heard from Tim McDonald about walking in and seeing the patient right away? So that's something that's got to be talked about how that's being handled. Is this really a tool that you wait for 5 months and then say, oh, let's do candor? Or is this a tool that you try to weave in from the beginning along with the communication? But you have to give written notice of a right to legal counsel, what the statute of limitations is in Iowa. Then that all candor communications will be confidential. And that is, it's a very broad net. Any communications, anything generated is completely protected to the level of peer review or professional review, which frankly is one of the very strongest privileges that exist in Iowa as well as in Colorado. If that is signed and the patient agrees to these open discussions under the statute, then everything else from there on out is completely confidential. So that means any investigation, and one thing I don't think, because this issue has come up, I think if a hospital or a physician practice does professional review on a patient, I don't think candor allows you to talk about those confidential proceedings to the patient. However, you can conduct your own investigation, and certainly you can use some of the things learned in professional review to help steer that investigation. It can share that with the patient. And you can tell them, okay, this is how we're going to change things. This is how we're going to make things better. And none of that is considered to be in this, admissible as well. So what candor also allows, which is extremely unique, and this is the most unique part of the statute, is if you decide after investigation that compensation is warranted, that you feel, okay, it probably wasn't the best of care, inappropriate care, patient was injured, so we think reasonable compensation is warranted. You can do that within the candor system. One thing that Mike McCoy taught me, and I talk to Mike a lot, I love the guy, he's very helpful because he's done several of these cases. This is a resolution program. It's not a compensation program. And so that's a really important distinction, that we're trying to move toward resolution for this patient and their loved ones and their family. That may not be money. It may be, I want to know that things aren't going to happen to the next patient, or I want to know what happened here. And I have a ton of cases that people really didn't want to get reimbursement. They want to know what the heck happened, and is it not going to happen to somebody else? And so it's important not to default to compensation. If you decide that compensation is warranted, here's where it works. So like our program called 3 Rs, which is for cases where we do an expense reimbursement, different than Candor, talk about it some other time. It is physician initiated. It has to be. It has to be that the physician or healthcare provider or hospital has to say, hey, look, we've got this program, like to go into it. Because if you sit back, if you keep your head down, if you keep your mouth shut, and you get a claim or a demand from patient or lawyer, you are immediately in the world of gotta report it. Because the National Data Bank says any money paid in response to a written claim, demand for payment, that's a claim. You gotta report it. The medical boards of the states usually have an even more expansive definition. So you can make a offer of compensation. It can be extended in writing, again, healthcare initiated, and then you again advise the patient of the things I've got up on the board. One thing you've got to make sure for this to work, we have to have very savvy plaintiffs' lawyers. Plaintiffs' lawyers that agree with the process, understand the process, and understand that it can be an effective tool for them, their clients, and the healthcare provider. Because the minute we get a plaintiff lawyer that decides, well, I'm going to write a counteroffer and it'll be a demand, you're now in report land. So we've got to make sure that the plaintiff's lawyers understand the process just as much. And they were all in favor of this, as I understand it. The Iowa Trial Lawyers Association were in favor of Candor, because frankly, plaintiff's lawyers, if they can resolve a case and resolve it happily with fair reimbursement, they're all over that. They don't want to go to trial. They're great people. I've tried a couple hundred jury trials, and I've always had great relationships with them. So the other thing that's a big kicker in this is you can actually ask for release. So not only can you make an offer, you can ask the other side for release, and it is not reportable under Iowa law to the medical board in Iowa, nor to the National Data Bank. So anyway, that's kind of an overview of the law, because we've been talking about it, and that's it in a nutshell.
And we're just going to change to the backdrop slides and then start the panel discussion from here. So as I go to the panel, what we're going to try to talk about here is what are your experiences in general, understanding the CRPs in general, and then also specifically related to this Candor, and then where are the opportunities, where are the barriers. Talking a little bit then about poking the sleeping bear in the room related to, does the attorneys matter, do the plaintiffs matter, does the case work better if there's clear liability, or does it work better when we're just really unknown related to it? Does this written notice you have to do with open communication, create positive or mistrust related to the family? Is it best at what time? So those are the kinds of things I want to talk about. I do want to touch on, because this is a passion of mine, that Tim let into a little bit, Mark let into a little bit, but I think people have heard these 7 pillars. What the heck are the 7? We're talking about one of the 7th pillar, and this is the one that oftentimes gets people tripped up, and it bothers me a little when people talk about whether or not this idea of communication resolution program was, quote, successful or not, or they don't work or they do work, because they're simply talking about whether or not the 7th pillar works. And these are the other 6. Do you have early reporting? Do you have the communication, which we talked about this morning? You have a team that knows how to do it and keep the family involved? Do you have care for the caregiver? Do you know how to investigate in a timely fashion? Do you actually improve from your data so that if one of your units continues to have the same problem, does the other unit know about it before it has the same problem? Do you do what the aviation industry has done, which is learning from each other's mistakes? Do you teach that and feed that and close that loop back? So those are the other 6 pillars, and with that, we'll get into we've talked a little bit about the specific requirements, but we want to know, as we get through in the questions I have, what are the benefits to healthcare providers, institutions, and systems, and what are the benefits to patients and families? And with that, why don't we start with what are your experiences, and we'll, again, open from the outside. So would you want to start with
Sure.
that, please?
Again, Tom Jones, I'm with the Bradshaw Law Firm, and I do know that we're having an attorney panel that's going to be talking after this, and I'm very aware that the people that are on this panel are here, and they also, I believe, have a little bit more experience actually using the Candor law and effectuating a resolution to these cases. Knowing that this is a panel that has insurers here today, I think what I would like to focus on is my experience on the questions that I'm getting from the insurers more, because I do believe that the other types of issues will be handled by the attorneys in that other panel. But right now, I think the biggest question I'm getting from insurers that may not be, there's a big continuum on where people are, where these companies are in utilizing this. And there's a big, so I get the question, should we be covering these types of settlements? And how do we cover those? And I'll be honest, the learning curve on this is still going forward on whether and how we implement strategies with the insurance companies and having policies that cover this sort of thing. And so that's my experience right now. I've talked to the attorneys that have actually utilized it. I've given a few talks on the Candor law and its pros and cons. But I think the biggest hurdle right now is when, under the obligations of insurance companies to open claim files and what their obligations are when those claim files are opened, and then how do we effectuate a resolution and cover these types of things when all of this stuff is going on? And that's where I stand.
Summer?
Thank you. Well, this is certainly Candor is not unique to Iowa, but this statute is so exciting, and it's also very new. So we at MedPro have not had a lot of experience yet in going through this Candor process. As we look at it, though, as we look at this particular statute, we are seeing how important it is to educate, and how important, I think, for all carriers to educate their insureds on the availability of the process, and also how important it is that you abide by the letter of the law. Some potential pitfalls I see, certainly, are if you don't abide by the letter of the law and give the proper notices, you might be creating a huge trail of evidence that you don't necessarily want out there. I would encourage all of our insureds, I would encourage anyone to involve your insurance company at the earliest. I certainly can't answer whether it would be covered under anyone's particular policy in any given situation. But is it a potential claim? If no one's actually made a claim, if no one's actually come to you and said, I'm going to sue for damages, is there a potential claim out there? Is there an incident? That's something you've got to discuss with your carrier. Your carrier may wish at that point to retain counsel. Maybe there are in-house resources also. But if you don't have a risk management department that is attended training sessions like this one, you need outside help, and you should be engaging outside help, asking your insurer if they will engage outside help in those situations. And in thinking about personal experiences, and I don't just handle claims in Iowa, I'm thinking about other states where don't have these sorts of things. I'm thinking about good doctors and good healthcare facilities who are hoping to initiate Candor sorts of discussions outside of this, and they have said things that have caused issues in the defense of claims or in lawsuits later on that I think if there had been discussion and investigation and legal advice beforehand, that wouldn't have happened. I'm thinking of one, not in Iowa. I'm thinking of a situation where there was a retained object after a knee surgery. And the surgeon wanted to be a stand-up guy, and I admire that. And he said to this patient, "I'm the captain of the ship. This is on me." Well, don't say those words, please. And I appreciate you being a stand-up guy. I appreciate you didn't want to throw anyone else under the bus. But this is a discussion that we might want to have had with the hospital as well, and with other participants in the surgery. So that's an example where I think everyone needs to talk beforehand and investigate thoroughly before initiation of these discussions are made. There are also situations where a candor discussion really needs to be discussed with criminal counsel. I'm thinking if there's a potential criminal investigation having to do with anything, it's certainly, maybe it's not disclosures that can be made right away. So I would encourage discussion with the carrier and discussion with counsel early and often before the process is initiated. So that's what the takeaway that I would hope that people would have. But I think I'm really excited about the law. I'm really excited about the training opportunities that exist for it as well.
Thank you, Summer. Mark, you want to?
So there's a number of practical issues, but I won't, there's a lot of them, but I won't raise those, and if you ask in the future, but we got Sean Gelsey, who's our VP of Claims, and Jerry Lewis Jenkins, who are Chief Operating Officer. And so what's really, really important is whatever carrier you're with, whoever you're insured by, we really emphasize that as soon as there's an adverse event, I mean, within hours, if possible, call the carrier. And it's not necessarily just to put the carrier on notice. It's that now you can see there are a number of triage questions that we have with that caregiver. First off, how you doing? You doing okay? You want to talk to somebody? We've got a caregiver program that we can help you out in dealing with the stress with people that have gone through this before. They're not going to talk to you about the case. They're going to talk to you about how crummy it is for you at this point. About our 3 Rs program, which is expense reimbursement. Is this case maybe one that will be worked well in 3 Rs through expense reimbursement, but because it's a case we can start giving money within hours to a patient, it's got a cap to it. And it's, the classic is knocking out the bridge by an anesthesiologist, $5,000, let's fix it, let's move on with our lives. This now has become another tool that needs early occurrence reporting, because the way I envision this is this weaves into that whole model. So you have to decide early on, when mom is lost because the oxygen tank on the anesthesia machine wasn't filled properly, and 2 kiddos and a husband are sitting there and saying, "What happened to my wife?" I don't think you want to strategically figure out, okay, what's the best time to start candor. I think it's an immediate program. Then you don't have to lay down on the sword or do anything else at that first meeting. It's going to be a case-by-case determination using good judgment about when these factors come into play. I will talk about one barrier that Sean and I have talked about a lot. I put together, I think every practice in Iowa should be Candor ready. Candor ready. Have your forms ready, have your team ready, and then if this happens, this can be a choice. You don't have to do it, and no carrier should force you into doing it. Probably every carrier should have a discussion with you about it. So the one barrier is, okay, you got these 3 or 4 forms that the patient has to sign. Okay, when do you give the patient those forms? And how do you convey that? Hey, here's some forms for you to sign, and this will allow me to be open and honest with you. Okay, well, why wouldn't you do that anyway? And I don't want to buy the Subaru today. Thank you very much. So again, it's a judgment thing, and we've learned, because we've had some cases we've put through Candor now. So we have learned, again, kind of it's based on the fact of the case. Mom lost, 2 kiddos, husband. You don't want to be talking about forms at that first meeting. Maybe if it's an infection that lingered on, no residual damage, etc., maybe the forms are fine to talk about in that first meeting. That's where you need a really savvy lawyer You need a real savvy claims adjuster. You need a real savvy carrier to be able to help you work through those judgment issues.
Great. So let's poke some sleeping dogs here. What about diversity of insurers? I know that you'll hear this afternoon from Michelle that when we looked at this, and I've been looking at CRPs for about 12 years at least, and one of the major barriers that happened, these all came out of vertically integrated academic medical institutions. So UIC, Michigan, Lexington VA were pioneers. They didn't have a diversity of insurer. Is it an unsurmountable barrier? How do you deal with it? Summer, you want to jump? You want to?
I think that, I don't think that is, it is a new concept for Candor. I don't think it has to be a new concept to all of us. Insurers are accustomed to working together. In the defense of a claim, we have so many cases where we have hospitals and we have the surgery team, we have the anesthesia team. We're accustomed to working together, to having defense counsel meetings after the fact. I don't see why we can't have them before the fact. I think if it's a hospital that's initiating the conversation, if that hospital brings in any other separately insured healthcare providers, for instance, please, talk to your insurer. Would you like to participate in this process with us? I think that's something we do later in the process. There's no reason it can't be done earlier, and I think it could be really helpful if it's done earlier.
Right.
Yeah. I mean, I believe there has to be buy-in from all of the insurers that this is an effective tool. Some of the barriers that I think might come in is when you have different insurance companies insuring different professionals, is that you're going to have the same thing that happens once a litigation has started, that based upon the attorney and people trying to figure out where the responsibility lies, that you're going to have some argument, and what are attorneys but advocates that are trying to push for their clients, and they're going to try to figure that out. One thing I do want to say about getting the help and assistance for physicians or the practitioner right away, that would be, I think that would be one of the best things to come out of the Candor law in Iowa, is that insurance companies decide to perhaps cover some sort of counseling services, or have risk managers from the companies themselves actually be able to talk to the doctors. I know in my own practice about 10 years ago, I started referring physicians immediately, everyone I got in, to be able to speak to a psychiatrist that I know here in Des Moines that regularly has been sued himself and regularly works with physicians. 10 years ago, not one single physician, mostly, would accept my offer and go see this person. I'm finding out now, as I talk to probably the last 12 to 15 cases I've seen come in my office, about 7 of the physicians take the referral, pay it out of their own pocket for the counseling services. So I did want to address that. That might be a consideration as the companies decide what they're going to cover and how they're going to do that, maybe 1 or 2 visits with a psychiatrist. But, again, what is the incentive for the malpractice carriers is that this is ultimately going to result in less claims, less legal claims, maybe less tort actions, and it's also going to save them money. And, what are some of the things? I know when I first heard of Candor, and I was a little late to the game. I was not following the legislative sessions and didn't know the Iowa Medical Society was even working on this. You're suspect, right? Can this really work? And, from a defense attorney, I was like, why is the plaintiff's bar so excited about this? That's the question. Why do they like this so much? And so you delve into that a little bit. And I think it is true what they say, though, that it works for earlier resolution, and it makes everybody get to that resolution sooner. But also I know from the insurance companies, the concern is, if we begin this immediately upon notice of a claim or an adverse event, and we get a counsel involved, that starts the ticker on attorney's fees for the insurance company. And I know there is a push to reduce those attorney's fees. So you have a lot of things that are coming into play immediately. But more specific to your question, I think the education, and as as companies and insurers find out that this is something that their insureds want, then there can be the education and the knowledge and the requirement that these insurers know what are going on, the claims adjusters and claims attorneys and claims professionals know what's happening and say, okay, we're going to have that tough talk about division of responsibility much sooner than we would in a regular tort action.
Mark?
So I think multiple carriers is probably the single largest barrier for Candor to be successful. And it's just, this statute requires a paradigm shift to get away from the keep your head down, keep your mouth shut mentality. And I'm an ambassador for this because I've lived through 40 years of gross inefficiency in the tort system. And, you know, we've had a Candor case here that Doc Carrick taking care of, name names, de-identified, but Doc takes care of a patient who dies in the hospital. We want to do a Candor, the hospital says, no way, we're not getting involved in that. So, you know, I think people have to realize this isn't a let's go to a meeting and pay him money type meeting. These are your care people. This is who cared for your mom. This was who was in the room when your mom died, the doc and the nurse. So we're here to help you heal and move on. And if we don't make that paradigm shift, because, you know, carriers and defendants have a bad way of thinking, okay, if I don't do anything, the doctor will take care of the case, or the hospital will take care of the case. I will tell you, after doing it for 40 years, there's all this mishmashing and people yelling at each other, and you go through 9 or 10 months of, I owe 7% instead of 9%, you know, in this case, and frankly, all comes out the same at the end. You've just spent a year of flopping around and yelling at each other, and you basically get the same result that you probably could have gotten 9 months earlier a lot more efficiently. So I think once carriers really grasp that, then I think this can have a chance. Otherwise, it's great in the closed systems like Michigan and Illinois. You know, I know Rick Boothman pretty well, and great guy. He was a defense lawyer. He's at Michigan. He's kind of the final arbiter of everything. He knows the docs. He's got employed docs. He's got the hospital. He's got the money. He talks to the patient. Well, that's a real different world than MedPro and Copic and CNA grandfather who's not here. But big thing, the three of us, we're all here.
It really is.
And that's a big statement.
And I can,
Summer, yeah. Go ahead.
I was just going to say, on behalf of Tom Trepchek, who's not here, if he were here, he would say this. My name's Connie Alt, and I've worked with Tom on resolution of a number of claims through Candor with Karen Lorenzen, who's also here, and we faced the issue of not having all the insurers participating. Great River does have a large group of insured physicians as part of the hospital, but their emergency room physicians are insured elsewhere, as are their radiologists, and so they have faced this issue. We have invited the other insurers to participate. In at least one case, they came but notified us as kind of we walked in the door that they weren't going to pay any money, but they were there, and so we disinvited them. It told them to sit out, and then we resolved the case with Karen at the end of the day, and then made a claim directly against them under our contribution statute, which I think, and we told them we were going to do this and it would put them at risk because now there is a claim, and they are therefore outside of all of the Candor process. So we've gone through that, and it's not perfect, but it works. And I think it did take Great River and CNA. They had to decide. We kind of planned on what we were going to do if that in fact happened before it happened, so we were ready for it that day. But that is in fact what happened. We basically told the insurer they weren't invited. We'd see them in court. We were going to sue them for contribution. And frankly, the settlement was so reasonable that even if we never get contribution, it was the right thing to do to settle the case that day. And Karen's client was helpful to us in giving us written statements, kind of a written, is it like a to help bolster the claim that we were making, that we were asserting against the other carrier. So, and I think we face that. I know that we have another one where we haven't done the Candor Conference yet, but there's another person that's not insured through CNA, and they've been invited to the Candor Conference. And I think carriers have to make a decision, but I think that's the downside for them. If they choose not to participate, they have their insureds to answer to. If they had an opportunity to be part of what might be a very reasonable settlement, and their participation might be quite small, and they may get a lawsuit afterwards.
The thing that I would add to that is part of why it works is not, Connie and I have been trying cases against each other for 20 years. But part of why this process works now and why it worked in the face of someone literally walking in the door and saying, oh, hi, how are you doing? And I'll tell you straight up, what he said to me was, well, your claim's against them. And I said, well, I don't think that that's accurate, but thanks so much for all of that. And we sent him on his way and we worked it out. And at the end of it, it was Connie's hospital being willing to pay a little more than they had intended, and me getting my client to agree to help them, because we definitely saw that the ER physician who didn't want to participate was part of the problem. And so it was this, you know, typically the line's drawn and you're on one side and they're on the other, but we got this resolution. The conference itself was very valuable, I think, to the providers and especially to my clients in terms of what they learned and what changed at the hospital. But then there was also this joint sort of, oh, well, this guy thinks, you know, he's above it all, but we're going to assist the hospital now in this regard. I've never done that. You know, in 25 years of doing this, I've never done that, but it was the right thing to do. And I think the process is what brought us together.
And something a lot of Iowa lawyers have told me is that because this process is patient-friendly, they have reduced their contingency fees a lot.
Every time.
We see 40 and 50% contingency fees in Colorado now. So if there's a recovery, the lawyer gets 50%. So this is, again, this program is all about focus on the patient. What's right for the patient, what gets money to the patient, because that's always going to be to the benefit of your healthcare provider. So I applaud the plaintiffs' lawyers who are charging less to accommodate this system.
You know, and it'll come up in our panel, one of the questions that were posed to us. Our agreement's the same heading in, but we've never charged what our agreement allows us to charge. The agreement stays the same in case Candor doesn't work.
Right.
You have your attorney fee agreement in place in case you're going to spend 2 years and $100,000 litigating your case. We have never charged the full fee. It's always, you get in there, you talk. It's an odd process, but you get in there, you talk, and then you figure out what's best. How do we make this work for everyone?
I was just thinking of a situation that I had, again, non-Iowa, and without the protection of the Candor law, which might make me lose a little bit of sleep, a lot of sleep, but again, sometimes it's just the right thing to do. We had a situation where a hospital reached out to our radiologist and said, do you want to participate in this? And also to the ER doc, do you want to participate in this as well? The ER doc said something to the effect of, no, but we're using this as a teaching tool. Maybe that means you should participate in a Candor sort of conference. But the hospital and we, for the radiology group, ended up having a discussion about how we're going to investigate this. We had an agreement we were going to share, and this is before there was a claim, before there was ever a claim, we were going to go out and get causation reviews, we were going to share them. We've done that. We've got this information that we've shared, and now we've got this ER doc out there who doesn't have access to that information, and they're going to be far behind the 8 ball if and when the claim does come. And in that case is one where we did make a disclosure to a patient. So I do think there's potential for everyone to work together. I think that there is a massive learning curve that conferences like this one and people like the people up here are really helping a lot to bring everyone up to speed.
We haven't talked very much about the last bullet up there, which is maybe are we communicating the benefits to patients and families related to this? And the obvious ones are, we talked about the Candor law, which is Mike could say towards the providers and the health systems, it provides them with confidentiality and it provides them with some protection from reporting. But I think there's a significant benefit to patients and families we haven't talked about. I mean, the obvious one is that we're going to be on an accelerated process. And I think we have to echo what Bruce and Tim said, which was that every minute of harm is another harm. And I think when you get, I'm going to be a little soapboxy here, but when you get if you as a systems people are having your carriers dig in their heels and delay, which actually works in the old school, works to their advantage. I mean, it's like, yeah, let's just stay quiet. The other people probably will pay, and we'll see if we skate along. There's a harm going on there. And I think in the back of your mind as providers saying, you demand better. You say, look, the patients and the families are suffering as a result. We're not going to let that sleeping dog lie because we're not going to contribute to that harm. And my oath was to do no harm. So I think let's talk a little bit about benefits to families, maybe.
Yeah, and Connie Alt's statements reminded me of one of my scenarios here. And that dovetail well into the patients and families benefits. So I got a solicitation from a plaintiff's attorney that wanted me to engage the candor law on behalf of a professional, and because of the letter that the doctor got, he notified his insurance carrier, and it was right when the new statute had been enacted, and we were still trying to figure out all the details of what it was. And I have a regret on this case. Talking with the insurance companies, we didn't think it was a mistake. We didn't think it was negligence. And so my directive, as with part of my advice, we said, no, we will engage in a candor conference, but you better know right from the start that there's not going to be any money put on the table. And so what did that do? They came back and said, well, if there's no money that's going to be put on the table, then we don't want to do it. So that quickly identified the issue. But I think thinking about it, from those good statements that we heard from the presentations earlier today, probably should have maybe withheld that information at first and engaged in the candor conference, because obviously the family wanted to learn what was going on. And I should have recommended to the insured that we do that too. And then at the end of that, perhaps with the claims adjuster being there as well, or upon my representations talking with the insurance companies and the physician, maybe there would have been a change in tune, but at least there could have been an open discussion about what occurred. And that would have been a benefit of the family. Let's face it, the difference, health professionals give bad news to people all the time. My sister runs the program at the University of Iowa College of Medicine that uses actors to improve patient care. And so they're taught to give bad news. What's the difference about this? I think society perceives that the emotional damage that's associated with a bad outcome that was caused by negligence, people die, people have cancer. You're telling people, I was a speech language pathologist before I was an attorney. I told many, many families that their kid had autism, or that the doctor, or that there's a developmental delay, or that the child stutters. And it is a loss and a tragedy and sad. But the harder part about it then is that you're saying in these circumstances that the actual damage was the result of someone else's negligence, which heightens all of the emotionality that people are talking about. And perhaps, had we prepared correctly, it would have diffused at least the emotions that are possible. And we all know the examples of plaintiffs or patients that will never be satisfied. They're going to be angry for the rest of their lives, and no amount of money is going to make that better. But at least we should have tried. I think we should have tried and just talked. And the protections that are available, who knows? I mean, it might have really made a good situation for everybody involved.
I have very rarely had someone react with anger. It certainly happens, as Tom said, but much more often when there is a disclosure, even of a medical error, there's usually thank you. And this is not a magic bullet that's going to make all lawsuits go away, but if you can take away the feeling of anger and deception, even if there is litigation, I think it can be faster, it can be resolved more quickly, and that not only does that help heal both sides, but it will save money in the long run.
So Tom told me that story when we prepped a couple of weeks ago, and, I think a huge opportunity will be missed if candor is used that way, because, and Tom was, sharing. I think if candor is used as plaintiff's counsel calls up and says, hey, let's do a candor, because then, you don't have to report it, so we can just get this thing settled and move on with our life. I mean, that's okay, but that is candor light. Because what we look this as, patient is talked to almost immediately. That might be just clinician. They're going to be coached up by Alan Limbitz, who's one of the best communicators I've ever seen in medicine. So that doc who's going to be totally stressed out because he hasn't done this or she hasn't done this before, Alan's going to work with them about how this information might be conveyed. Then we're going to say to the patient, we're going to say, look, we are so sorry what happened to your mom. We are going to do an investigation, and here's how we're going to do this investigation. And then we have somebody that becomes the main team leader on communicating with the family, and we have that team leader say, we have sent this out for review to Dr. Whitfer, and we're going to have him come back to us and tell us what happened. And if Dr. Whitfer doesn't give us a good review, we'll tell you that. I mean, that takes a lot of courage. That's a lot of courage to do those things. But does a person who lost their mom due to an oxygen machine being empty deserve that? Yeah, they do. They don't become evil because their mom died, So that's how we approach this. And then and if the oxygen tank was full, we defend good care. I mean, Copic is one of the strongest defense advocates. If we do the investigation and it shows the care was appropriate, we are very nicely, as nice as we can, going to tell the family, we're so sorry for the loss of your mom, but we think the care was entirely appropriate. And we just don't think compensation is warranted. If you do pay compensation, then you do.
Tim.
So, I love this conversation. The other benefit that we've learned through research recently is if you go in and have that conversation, one of the most important things you can do is get the patient or family's perspective on what happened. There was just data published from a lot of our people doing research. 80% of the time, you will find something in that conversation where you can learn and improve. Not that you were negligent, not that it was mistakes, but that you will learn and improve, and that brings value to the family. Because you acknowledge that. Thank you so much for that. This is an important information, and then you know where they're coming from. So that's the other opportunity lost, as you say, is you really could have learned from them. What's your perception of what happened? And it's just a great way to create that connection and the piece from that.
Jerry.
It occurs to me as I'm listening to this that we are all in a position right now where we're working in organizations that are going through a culture change. This is a very different part of the world that we've grown up in and what we've experienced before. We know in the delivery side of healthcare, quality improvement, patient safety, high reliability organizations are the order of the day. We sit a little outside of that world, but honestly, we should be living in that world. And so, as we're coming along, and I'm thinking more about the multiple insurers on a case, all of us are going through different phases of that culture change. And you, as consumers of what our product, need to push us. You need to push us to be on the right side of right. So this is a wonderful opportunity in Iowa. I wish it could be all over in every state, but this is the right thing to do. And we've got to keep encouraging each other to do the right thing, even though it's a little uncomfortable and keeps us up at night.
Is it the second or third state that has adopted this?
Massachusetts and Oregon
Yeah, I thought
had
it
it,
was-
but neither one were very effectual.
So there is a difference between communication and resolution programs, which obviously can be done completely without statutes. You don't need a statute to do all of these steps here. I keep putting the 7 pillars up because I think it's important that we remember all the other ones. The statute has the very specific, notice requirement that then triggers some certain benefits. But we've got.
I think you had a question back
Yeah.
there.
Oh, yeah, please.
My client is self-insured, we rarely deal with other insurance providers. But what do you do, and maybe Connie, they'll talk about it, when you have a provider who, maybe I'm the captain of the ship, or maybe is incredibly defensive, saying, I didn't do anything wrong, why do I need to talk to these people? What are the experiences in maybe putting someone else in the room instead? And does that then affect the benefit to the family? If it's not the surgeon who's sitting across the table from them, if it is maybe the chief of surgery instead, or what have the experiences been with that, when you have the ability to use your whole institution and everyone available to you to do this?
The law is quite inclusive, isn't it? for the-
Yeah, and I know Tim and Alan can talk about this out the yin-yang. Bruce, I don't know you very well, so I'm sorry, I don't mean to exclude you. I do know Tim because I worked with him on the 7 pillars in Colorado. So just from a legal standpoint, I'll let them answer the empathy and that stuff. Legally, you can include anybody in these conversations. They have to sign a written form that says agree to confidentiality. And once they do, it's like they were in a peer review process. Now, if they violate that, one, you can tell them to cut it out and get a court order to cut it out, and it'll be excluded as evidence in anything if a judge reads the statute. So, yeah, in our instances, we had, and we actually, the guy who became the team leader in one of our cases, to kind of keep the contact with the family, we had him sign a confidentiality, just so everybody knows, this is professional review, peer review, cannot be discussed. And then there's the empathy piece she's asking about if you don't have the most empathic doctor,
Right.
what do you do?
So we do that in just,
Which would be unusual.
You find the super communicators and you balance
right,
them out.
exactly. So we've built, and Tim's built, and the system calls on communication teams, a situation management team that has a communication coaches. And if you've got the person who's, one construct deep, as Bruce talked, maybe they might be in the room and just tell them to sit and watch and smile, and let the high construct person to work through it. But yeah, it's a team game, and it can be a process. I think the other side of the story is also and it was said before, is there aren't any magic words, and the family, as you know, is not going to remember but about that much of, you may have scripted and done perfect job and gone for a 90-minute thing. If you were to ask the family, what did you remember? It's going to be remarkably little.
They'll remember the gist. So the gist will be, were you empathic? Were you saying,
Yes.
I'm sorry for what happened? Or were you they'll remember the emotional gist and tone of the meeting.
Exactly.
But they're not going to remember the details. That's why when we coach, we often coach people to worry less about saying exactly the right thing and worry more about having the right goals. So if you go in there earnestly and sincerely having the right goals, patients will forgive tremendous amount of awkward attempts to say the right thing if they're pretty confident that you're there to tell them what happened, or that you're there in this kind of spirit of honesty, including honesty about, we don't know whether it was our fault yet, and we're not yet prepared to give you a bunch of money or apologize for making a mistake, but we're here to tell you what happened. I think they'll forgive, and we've seen it happen where it's impossible always to say the right thing, and patients don't really expect, our patient advocates never expect that. They want something else, which is this intention, and then they're making an evaluation about your intentions in that first meeting. Are you here to pull the wool over our eyes? Are you here to stonewall? Or are you here to comfort us and help us and try to explain what happened?
And in our coaching, we've always told people in high stress situations, we always are going to retreat into our reptile brain, which is basically, can I trust this person or not? Do I have to run, or can I stay? And really, that may be what
Yeah.
you're getting, maybe what that may be a good result.
Right, if you can not trigger the fight or flight response in the family, you've succeeded.
Yeah. This is great, keep going.
I have a question. I'm a medical educator as well as a family physician. And one of the things we're being taught in medical education, or we're teaching the students in medical education, is that we're all part of interprofessional teams. And in addition to the other physicians that are helping take care of the patient, there's also nurses and respiratory therapists, and especially in an environment like this hospital, there's residents and medical students too. We're all part of a team, we're all supposed to take care of the patient, we're all doing situation monitoring. But let's say there's a bad outcome. How, some of the we're a team retreats. Let's leave the doc out there.
Why don't you do that?
So a couple things I would do, and then that is the team for bullet point 4 investigation is critical. They may be, one of those team members is probably the one who has the golden nugget that tells you what actually happened or why. And so they can be valuable to the investigation. I'm not sure that our experience is that it's certainly not good to outnumber the patient and family. You gotta figure out, you gotta engineer the right amount of people with the right person in the room related to that discussion.
What we teach is the huddle, this concept of a huddle where
Which is we teach that, yeah.
so the event happens and then you're gonna huddle. But I think what I heard you saying is that some people head for the hills when something bad happens. Is that what you're saying? And they're not willing to be part of the team even to huddle?
Or, I was actually coming around to a second question. So if maybe their RN has something against doc or respiratory therapy has against anesthesiology, and they contaminate the waters by saying a statement perhaps unproven, but whatever their conjecture is. So that's not necessarily that they retreat. I can totally understand that. But if they make accusations perhaps that are unfounded. So that leads to the second question, which is, and Summer, I was hoping you would address this. How do you prepare a hospital system, medical educators to be ready to do Candor, to have the crucial conversations ahead of time, to understand peer review process so that Candor works? Or am I asking too big?
So that's the critical thing, because this is not easy, and you guys, making systems Candor ready doesn't happen overnight. If there's this is not about the law and the piece of paper. This is about the culture and all the other stuff that goes into it. And Tim, that's what you do.
COPIC has been so supportive. So one of the ways that we've gotten to this is we've now done 10 years of patient safety deep dive workshops where we brought nursing students, pharmacy students, medical students, and residents together to get to what you just said. COPIC's been a huge supporter of that. We did many, many years in Colorado. We're now doing that in a lot of places around the country, working with you guys to bring in, because you're educating the young, so then when they become the faculty, they get this and they know how important it is and to work together. So I don't know, Alan, if you want to talk about that. That's huge support you guys have had for.
There is system change and culture change doesn't happen
Yes.
with the passing of a law or a change. I think you're exactly on the right place of where it happens. I would just say you're going to have to keep working at it. The principles are simple. The adoption is the really difficult, and get some easy ones. So the near misses are great because no one got harmed, but you can do all the stuff for a near miss, and you could. It's like your own mock situation, because you could actually do and say, we were just lucky that the actual harm didn't translate to the patients. Let's play that it actually did, and let's go through the whole thing. There are some real simple ones in which to do.
Or you could even talk to patients and families about near misses.
Yep.
You could take this its honesty to its radical, limit. But I think that what your instinct is correct, that it's soup to nuts. Medical students have to understand something about quality improvement, something about human factors, something about how reporting works, something about how the malpractice system works. What are near misses? But they have to understand all this, so that when they get into practice, it's not just suddenly dump them on top of all the clinical things they're supposed to master. This whole other worldview about, being honest and understanding medical liability. They have to, or understanding quality improvement. They have to understand something about that. But your other point about what if somebody on the team throws somebody else under the bus and contaminates the water, I think the goal is to try to prevent that from happening by identifying early on. So we have to find people with enough emotional intelligence and enough emotional maturity and kind of equanimity in these very high-stakes situations that they won't do that. And we have to try to keep those people who we know are prone or likely or vulnerable to blaming others in these high-stress situations. We have to try to keep them out of contact with the family. They can be in the huddle, but we have to, this is where we have to try to exercise judgment about who gets to actually be in there with the family. And it's to have that much equanimity, to have that much distance from your feelings in such an intense situation, it's a rare gift. And to be able to not blame others, it's rare. But we really think your instinct that this does tremendous harm. If you get in there in that first discussion with the family and they're said, that doctor's forever ignoring important instructions that I give him, then all is lost. It's very hard to recover from.
And I'll just make one last point. You're uniquely poised in Iowa because as much as we hope people will do the right thing, we also know people need to be incentivized to do the right thing. And, at COPA, we try to do the right thing, but we've got EMR points and that reduces premium and everything else. And so I think you're living in la-la land if you don't say, how is this going to be a benefit to you? Not only is it best for your patient, who you owe the highest duty under law to, like I do to a client, but how is it going to benefit the doc? And there's a little bit of delayed gratification, but if a doc understands that the stress of going through a malpractice case, doctors lose their autonomy when they're thrown into the malpractice world. Their life then is controlled by others, and they hate it, and they're stressed about it. This is one where they can actually be involved in helping themselves take care of the situation rather than turning it over to a Mark Fogg or a Sean Gelsey. They can be involved in the process. And that's very scary now because the paradigm shift has not occurred. But once we say to you, here's your choice to talk to your patient, do the right thing, be able to be involved, be able to use your skills, or you can just give it to these guys, and we'll see you in about 2 years, and you may get hit for $3 million, kind of thing. You've got a real chance here in Iowa to make a difference.
I have one more suggestion on that. If the person who is resistant, or if the person who in this huddle, before you talk to the patient, says, I'm going to go in there and throw these nurses under the bus, maybe just, and let's say it's a physician who is not with that institution. Perhaps the gentle question of, have you discussed this with your risk management department? Just the suggestion that not you need to go lawyer up, you need to put your carrier on notice, but have you discussed this with risk management? They might have a different perspective. I encourage you, before we go into this, have a discussion with your risk management person, department, carrier.
Tom?
Well, I do think a culture change needs to occur if we have the law in Iowa, and so then I think the malpractice carriers really have to look into whether and how they're going to implement this from their own internal risk managing departments to provide education for their insureds. Now, why do a lot of lawsuits occur but for the fact that that one nurse that had an intimate relationship, not an intimate, close relationship with the patient. Yeah, exactly.
And that's why we're
And that's why we're here. And I've had that case too. So, no, the close relationship with the family said, well, this doctor did something wrong. Okay, or the subsequent treater. We don't like people going up to Mayo here in Iowa, because then there's some criticism of what the Iowa doctors did. Okay, and that is the type of thing that occurs that initiates the lawsuit. So if you can get ahead of the game, maybe you're explaining to the family a little bit sooner what actually occurred, and you're getting everybody on the same page. But it's going to have, I love the fact that they've identified that we have a tool to motivate people to make that change. And for carriers' perspective, I know if it reduces loss, then it's a good thing too. And not only just with the patient, I don't want to take that off, but.
So the good news is that we have this afternoon still to discuss. You have a lot of people around for lunch. We have to break for lunch right now. So thank you very much to the panel. I really appreciate the interaction.